Okay, so some questions before we do this site. Flat term, un plazo mínimo, plazo básico. Refutar with a T, I think I answered this already. Can you say libertad condicional for parole? Libertad preparatoria is the best option because libertad condicional is probation. There is only a couple of countries in Caribbean countries like Dominican Republic and Cuba where they use libertad condicional for both. So for a state examination, you cannot. You have to use libertad preparatoria because remember, parole is nothing else than allowing somebody who has been, let me show my whole face here. Parole is nothing else than allowing somebody who has been sentenced to a period of time in jail or prison to basically leave earlier, like 1/3 of their sentence before, like if you were sentenced to 9 years, then after year number 6 or number 7 or number 8, you can request it, and you could technically leave, 3 years before but the only purpose is to prepare you to go back to the society. Because it's clearly understood that if somebody has been in state prison for 6 years, it's going to take, or 9 years, it's going to take some time until that person can function in the society. So that's the reason of parole. And this is in Spanish, the word reflects that, libertad preparatoria. Lo prepara para volver a la sociedad. This is entre comillas. Yes, that's correct. The two quotes is entre comillas, and the two parentheses is entre paréntesis. All right, so let's do this side translation, which is number 33. 1. El acusado le indica al juez que el acusado está conforme con la asistencia efectiva que le han prestado sus abogados. El acusado entiende que al celebrar este acuerdo, dicho acusado cede a ciertos derechos como se disponen en este acuerdo. El acusado entiende que los derechos de cualquier acusado incluyen los siguientes. You can see the word acusado a lot, right? Can you modify this? It's difficult because it specifically says defendant, but in English you have to use that noun all the time, but in Spanish it may not be necessary. So I kind of add some flavor to it by saying dicho acusado, but in reality you're stuck with this term throughout because of the word defendant is so often used. Now, the other interesting thing we need to be careful here is criminal defendant. I'll do the side in a second, but criminal defendant. Well, we have two types of defendant in the legal system. We have a criminal defendant and a civil defendant. And a criminal defendant is somebody, and then first of all, why do we have both of them here in the US? Because in the US, a defendant it's the same name given to somebody who appears in criminal or civil jurisdictions. You go to civil court and you have plaintiff defendant. You go to criminal court and you have plaintiff defendant. No difference. In Spanish, that's not the case. But in English, it is. So you have to specify criminal before to kind of let the reader know that you're talking about the criminal jurisdiction. And this criminal defendant, this whole thing is for us acusado, which we always use defendant as acusado because this is a criminal class and we're assuming that it is a criminal defendant. But the word criminal defendant is acusado and the word civil defendant is demandado. The problem that we have with the word defendant, if we remember from lecture number 1, is its lack of stability in English. It means, it could be it's a function of basically the jurisdiction. Now, in Spanish, when we say acusado, we're assuming we're in the criminal jurisdiction, which in our case, in this training program, that is the case until you go to the last class where we see some civil matters. So that's what we see when we see defendant, or when we say acusado instead of saying demandado. But the problem with this particular site is that it does use defendant all over the place, and obviously we use as acusado because we're assuming this is a criminal case, which indeed it is. When you read it, you confirm it. But at the last sentence under number 1 says the rights of criminal defendants. And you may be tempted to say for defendants acusado and for criminal penales o en lo penal or something like that. And to say un acusado en lo penal is kind of redundant. If it's acusado, es en lo penal. So that's why you have to be careful when you see the word defendant. If somebody asks you, how do you translate into Spanish defendant? You don't know. Because it could be, you need to have some context, right? But sometimes the context goes beyond just the sentence where the word defendant is being used. Because when the determination of on a transfer, when the stability of the transfer of a word such as defendant, right, depends on jurisdiction, you need to understand the whole site, not just the sentence where the word is being used. And that is because jurisdiction sometimes is not given on that sentence. If you read the first word, or the first sentence here under number 1, the defendant represents to the court that the defendant is satisfied that his attorneys have rendered effective assistance. You don't know here whether it's criminal or civil. You may suspect it's criminal, but you really don't know, and you only know when you actually get to the last sentence under number 1. So when you want to make a term stable based on jurisdiction, you may need to read the whole site, and that's one of the reasons why you read the site beforehand. One of the first things that you are going to do is when you look at the word defendant, you're going to make sure that document is in the criminal jurisdiction. Because it could be in the civil jurisdiction, and the translation into Spanish now changes. The issue here is that up to this point, we have only done criminal in this class. But when you go to the last course, which for you will be sometime in January, there will be a mix of criminal and civil, and you need to be very careful with it. And by the way, this same thing is for plaintiff, because plaintiff is querellante o parte acusadora, and that's in criminal. That's criminal plaintiff. But plaintiff in civil, in other words, a civil plaintiff is demandante. So we need to be careful. I just want to point that out, kind of leading to the last course. Number A. Si el acusado insiste en presentar una declaración de no culpable. See, if I'm looking at this, if persisting in a plea of not guilty, if this is the only information I have to determine if defendant is acusado o demandado, I know that it is acusado because you don't enter pleas in civil, you enter only pleas in criminal, right? Si el acusado persiste en presentar una declaración de no culpable a las imputaciones, el acusado tendrá el derecho a un juicio un juicio rápido ante un jurado con la ayuda de un abogado. El juicio se puede llevar a cabo por un juez, quien participa sin jurado, si el acusado, la Procuraduría y el juez están todos de acuerdo. B. Si se lleva a cabo un juicio ante un jurado, el jurado estará compuesto de 12 personas no peritos. Laicas. No peritos is the translation for this. No peritos. That word, which is lay person, is exactly the opposite of an expert. It's the antonym of an expert. Si se lleva a cabo un juicio ante un jurado, el jurado estará compuesto por 12 personas no peritos elegidas al azar. El acusado y su abogado ayudarán en la elección de los miembros del jurado al excluir, no remover, excluir a posibles miembros del jurado por causa donde se demuestre una predisposición real u otra inhabilitación. The word disqualification no es descalificación, sino inhabilitación. Oops. So, let me show you again, just in case you didn't write it down. Inhabilitación, disqualification, okay? And bias is predisposición, by the way. Bias, predisposición, parcialidad, ¿okay? Entonces, el acusado y el abogado y su abogado ayudarán en la elección de los miembros del jurado al excluir a posibles miembros del jurado por causa donde se demuestre una predisposición real u otro tipo de inhabilitación, o al excluir a posibles miembros del jurado sin causa al ejercer la recusación sin causa. That's peremptory challenge, recusación sin causa. I'll explain this at the end of the slide. El jurado tendrá que estar de acuerdo unánimemente antes que pueda dar un veredicto, ya sea de culpable o de no culpable. Al jurado se le instruirá que se le presume inocente, que no puede ser hallado culpable a menos que después de oír todas las pruebas, el jurado sea persuadido de la culpabilidad del acusado fuera de toda duda razonable. Y el jurado ha de considerar cada imputación en forma separada. Sí. Si se celebra un juicio ante un juez sin jurado, el juez determinará los hechos y después de conocer todas las pruebas y de considerar cada cargo por parte separada, determinará si las pruebas establecen o no la culpabilidad del acusado fuera de toda duda razonable. D. En el juicio, a la Procuraduría se le requerirá que presente a sus testigos y otras pruebas en contra del acusado. El acusado podrá cariar a esos testigos y su abogado podrá contrainterrogarlos. A cambio de eso, el acusado puede presentar testigos y otras pruebas a su favor. Si los testigos del acusado no comparecieran voluntariamente, al acusado se le requerirá el acusado requerirá su presencia a través de la subpoena power of the court, facultad citatoria judicial. En el juicio, el acusado puede basarse en su privilegio a no incriminarse para negarse a declarar. Y no se puede sacar ninguna conclusión de culpabilidad si el acusado se niega a declarar. Si el acusado desea hacerlo, dicho acusado puede declarar en su favor. Complicated structures that you will find only in the federal exam, not at the state level. Vocabulary-wise, this is not too complicated. But when you look at this site translation and you're trying to deliver, it has a lot of tricks, mainly in terms of repeating acusado, and also in terms of putting these sentences together. So there is, some type of issue that needs to be, there's a level of difficulty here that is not necessarily vocabulary. I do want to tell you that during the jury selection, I don't know if you ever participated in one, the jury, the judge or the clerk calls a certain number of witnesses, of potential jurors, and they sit on the jury, in the jury box. And there's going to be at least six, maybe 7 seats on the top, 7 seats at the bottom. And then they put another 7 seats at the ground level. And those are chairs that they put there. So they call maybe anywhere between 18 and 21 potential jurors. And then there are questions that the jurors have to answer. Those questions are on the board. They're just general questions such as whether or not you participated as a juror in the past, whether you reach a verdict. They ask you what your spouse, what is it that your spouse, what's your spouse's job? Questions, where do you live, what area? But then there are questions that are unique to the case. And if the case, let's say, is robbery, armed robbery, then they may ask you, have you ever been a victim of a crime of armed robbery, and blah, 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 blah. It is possible, although very unlikely, but it is possible that one of those potential jurors either knows the defendant or perhaps doesn't feel comfortable finding a verdict against the defendant for whatever reason, religious reasons or whatever the case is. And those cases, the attorneys, obviously in this particular case where the potential juror is unable to convict the defendant regardless, the defense counsel will want that person in the jury panel, but the district attorney is going to say no. So that's kind of it's called challenge for cause, right? Recusación por causa. And there are some challenges for cause, and the judge has to decide if there is a real good cause to challenge somebody and to remove it from the panel, excluirlo del panel. But besides those challenges or potential challenges for cause, the law provides both parties with 11 peremptory challenges. And a peremptory challenge basically gives each of the parties the ability, 11 times, for 11 potential jurors, the ability to exclude or to remove a juror without giving any reason. You may say, well, why would they do something like that? Well, sometimes you may want to have all females in your panel, so you will be excluding or removing males. And for that, you cannot use a challenge for cause, but you can certainly use a peremptory challenge. Or you may want to have people that live in an area where the police is not trusted. Of course, it kind of balances out, because if the defense wants somebody who lives in an area where the police is not trusted, most likely the prosecution wants someone who lives in an area where the police is trusted. Particularly if the evidence that is going to come in this trial, it all comes from the police, right? So those peremptory challenges are there for the parties to kind of remove jurors without explaining why. And that's kind of a lesson that we take from this site, that it is actually more at the federal level, but that definitely applies to state level when you look at the terminology dealing with challenge for cause, peremptory challenges, to remove a potential juror, excluir, that's an important term, right? And then subpoena power of the court, you have to remember that from the misdemeanor course, facultad citatoria judicial, that's when you can force the witnesses to come and testify. And if not, they could really be arrested. Okay, so having said that, we have one more site to complete, which is number 8. And we're going to finish that. We're going to do that right now. And that means that we have completed the whole book by now, right? Once we finish with site number 8. And then once we finish with number 8, we will take our break and we come back. I'm going to be doing monitoring of some of the sites that we have been covering. Nothing too complicated, but the whole purpose of this monitoring is just to get some feedback on your performance. So I tend to monitor people from on the sites that we did at the very beginning more than anything else, because it's been already 2-3 weeks. So let's just look at site translation number 8 now, so we can get this portion of the course over with. Site translation number 8 is not too long, as you can see, but it has some really interesting terms. So I'm going to leave that up to you. It's more as a federal level. It's not going to be at the state level, okay? So it's not something that it is too critical at this point, but we need to complete it, and there are certain words here that will become important. So let me give you 4 minutes to read site translation number 8, starting now.